more efficient is.
Mr. Hill, rather than have you repeat it again, I don't know if Marianne has started recording yet. Let me actually call the case so you can put your appearances on and we can proceed from there. Calling 210182 LT, Lauren McKinney versus Tawan Tate. Your appearances, please.
Good afternoon, Your Honor. Robert Higbee, P82739, appearing on behalf of Lauren McKinney, who is also present on the Zoom.
And good afternoon, Your Honor. Ryan Hill, P68445, on behalf of Mr. Tate, who's also on Zoom. Mr. Tate, can you state your name for the record, please?
Yes, Tawan Tate.
Mr. Hill, you were starting to say that there is an action pending in circuit court.
There is, Judge. This is an adjourned date. I did talk to my client. He's working on financing, but in the interim, prior to Mr. Higbee being involved, we did file a Third Circuit action for quiet title, unjust enrichment and breach of contract, which I believe Mr. Higbee has filed appearance on. I'm asking the court, and if some brief facts, my client's lived in the property since 2013. This is one of these, I guess, rent-to-own type of bifurcated agreements that I don't necessarily like, but it gave my client a certain credit if you look at even the agreement that was attached to plaintiff's complaint. And I think me and Mr. Higbee, or at least we agree that it's roughly around $36,000 that should have been applied to the purchase price. The issue we have, Judge, is that there's been a moving of the goalpost type of thing with the plaintiff. This originally started off with a purchase price of $130,000, and now it's got up to $240,000. So I'm asking the court to allow the circuit court to work out the quiet title action and the other various causes of action. My client has no problem paying into the court's escrow or directly into Mr. Higbee's escrow account. I told him that that would be a prerequisite if the court did grant my relief.
Your response, Mr. Higbee?
Your Honor, I'm objecting to Mr. Hill's motion to stay these proceedings pending the circuit court action. I did acknowledge service of that action. I have filed an appearance. I believe our answer is due in a couple of weeks. What he suggests about this, the relief that he seeks, I don't believe gives him any right, his client, any right to stay in the property while it's sorted out. In fact, the lease specifically calls for the tenant to vacate the property upon termination of the lease, which I believe it's undisputed was December 31st of 2020. And the lease calls for him to vacate it. There's no provision that he's allowed to stay in the property pending resolution of his ability to buy this property or not. There's no requirement that Ms. McKinney set any particular price with respect to Mr. Tate purchasing this property. Despite that, she's made a good faith, reasonable offer or reasonable offer to Mr. Tate to buy this property. He doesn't have financing, and there's nothing that permits him to stay in the property. And any remedy that he has is in circuit court in that regard. And I don't think it's appropriate to stay this action pending a circuit court action that may go on for months and months and months when there's nothing in the lease that permits him to stay in this property. He's been served with a notice to quit back in November. The lease was validly the month-to-month lease was validly terminated at the end of December. He's been properly served in this action, and there's nothing that permits him to stay in the property. So I think it's inappropriate at this time to stay this action pending resolution of the circuit court matter.
May I say one thing, Judge?
Please.
The plaintiff's own document attached to the termination, the very last paragraph says, additional provisions. At the end of the lease term, any monthly excess mortgage principal, interest and escrow payments made during the lease term will be applied towards the purchase price of the home, excluding any security deposits payments if tenant chooses to purchase the property. He is choosing to purchase the property. The problem is we've been given 7 days to get financing for a property that's gone up in value, according to the plaintiff, $110,000. This is a classic situation where property values go up and you have a landlord/owner that's trying to take advantage of the market. And I think it's unfortunate because my client, I figured it out, total payments over in excess of $140,000. Over $140,000, and he's going to walk away with absolutely nothing to show for it. I don't see the harm if Ms. McKinney is getting her regular payments and she's covering her mortgage payment. What is the harm? The only harm is my client's going to be homeless and out $140,000.
May I respond, Your Honor?
If you feel like you must.
Well, he suggests that there's no harm to Miss McKinney. Miss McKinney needs that home for her own lodging purposes, Your Honor. So there is specific and discrete harm to Miss McKinney if this is not allowed to proceed. Thank you, Your Honor.
I guess from my perspective, when we were last here, Mr. Hill did reference that there was an action pending in the Third Circuit Court. I don't know that he specifically said a quiet title, but at that time, the parties were looking for a trial date. So we didn't get into the meat of, like I said, what the Third Circuit case was. But if we were to proceed this afternoon, it's possible that we could come to a judgment and an order that was in direct contradiction to a ruling from the Third Circuit Court. So because the parties are the same in Third Circuit as in 34th District, and it is the same property that will be at issue, I'm going to err on the side of caution and grant Mr. Hill's motion to stay these proceedings because there is an action pending in the Circuit Court regarding, again, the same parties and the same property. Mr. Higbee, I'm not sure if your client is protected, if her position is protected so long as Mr. Tate continues to remit the agreed upon rental payments, or if there's some other, I guess, condition we could put in place while the Third Circuit case is pending that would satisfy your client. You tell me beyond the just a blanket order to stay these proceedings pending the outcome of the Third Circuit case. Is there anything else that the parties would request?
Who pays the insurance, Mr. Higbee? Is your client or just my client?
Your Honor, may I be permitted to talk to my client briefly?
Yes, sir.
Okay. Thank you, Your Honor.
Your Honor, am I in a breakout room as well?
No, sir, you are in the main courtroom running live on YouTube. Your attorney is here as well.
Press mute, Mr. Tate.
Okay, now, okay, I couldn't hear. Okay.
We're back on the matter of McKinney versus Tate.
Your Honor, I don't think my client's back yet. At least I don't see her.
She's not.
Not back.
May I proceed, Your Honor?
Yes, please.
Thank you. Your Honor, I had an opportunity to speak with my client. Thank you for that. She would like the rent to continue to be paid directly to her, but I would ask that you order that the rent be paid on or before the first of the month, consistent with the rental agreement. And I understand that Mr. Tate habitually pays late. So I would ask that you order that the rent be paid on or before the first of every month.
Judge, I don't necessarily have a problem with that. The only issue is if my client does default on that provision, he's a couple of days late. My understanding is plaintiff's only recourse is, well, there is no recourse. That's only if there's a jury demand, it'd be a waiver of a jury demand. This wouldn't affect the stay. But
There is a jury demand in this case, so.
what I'm saying is what I'm saying is the only recourse, my understanding is pursuant to the court rules, if there's a violation of the escrow order, is that you waive your right to a jury. That's it. Right? The stay was,
I'm sorry, Mr. Higbee is not asking for an escrow order. I thought I heard him say that the rent was to continue to be paid directly to the plaintiff, number one. And number two, although there was a request for a jury demand on the pleadings, I didn't see that the jury fee had actually been paid.
was that our demand, Judge? I'm assuming it probably was.
It was.
I thought we paid the jury demand. Either way, what I would prefer is whatever the lease is, I would prefer that stay the way it is.
That's all I'm asking for, Your Honor. The lease says first of the month.
Then that makes sense to me.
That's just going by. I'm asking that you enforce the lease. And,
Sure.
and Mr. Tate is late every month with the rent. And this is an effort to get my client the money and not create unnecessary hurdles to getting money that she needs. So I would ask that you order that he pay consistent with the lease agreement.
We'll stipulate that, Judge.
Anything else, Mr. Higbee?
No, Your Honor. Thank you.
Anything else, Mr. Hill?
No, just that the rental rate is currently,
The document I have says $1,500 a month, and that's from June of 2013. I didn't receive any indication that there had been a subsequent lease or amendment signed.
that's what I want to make, $1,500, correct?
That's correct, Your Honor.
That's fine.
So, Mr. Hill, if you would submit an order as to the stay and as to the understanding regarding rental payments, anything else? Mr. Higbee,
No, Your Honor. Thank you.
anything else, Mr. Hill?
Nothing.
Thank you very much. We're all set. We have a good afternoon.
Here.
Thank
Bye.
you.